So good morning, everyone. Welcome to the NBOSh National General Certificate. We're in the tail end of Chapter 1, Common Law, and a bit of the HSC powers today anyway. I prefer do this one first. This is the longer one. Just give me a minute, folks. Should probably pause back the recording now. Just yeah, sorry about that. I do have some. I'm about to do some consultancy work. So that was my clients of mine. I'm actually doing training this morning. So I don't know. Remember, I know you all only see me, but remember, this is an institute, right? So we have two trainers out this morning, one at Nutrient, and we have another at, well, a contractor to that same company, right? Yeah, so that was one of them, just making sure everything kind of going okay, right? Let me just see if how to start back this recording now. Or did it start back already? Hmm. It didn't say pause. I guess the recording is still going. I'd hate to lose a full recording. Your screen sharing is pause. Um, if by any chance we lose the recording, I know I have full ones on YouTube already, but it didn't say, as far as I can see here, it didn't say the recording was stopped. Can you see the PowerPoint in the background again?
Yes, sir.
Okay, good. Thanks. The options I'm seeing here is to pause the recording or stop, which means the recording is hopefully running, right? All right. So common law, if you remember from last week, well, we must remember last week, right? Last week was statute law, the law made by the land. And then, like, to get people to understand the law of the land, the ministers across it, which they call them a secretary of state, work together with the HSE to produce a bunch of daughter laws. Then the daughter laws are called regulations. And the history from last week class, and if it, of course you can listen back the video too, is that every hazard have a regulation, but regulations are long and nobody really have time to read all of them, especially employers. So what the HSC did, the HSC produced booklets and brochures and pamphlets for the employers to understand. Some of them carry different codes. If it's the ACOPS version, it carries L and a number. And if it's the guidances, it carries HSG or INDG and a number as well. ACOPs are really an extension of the law. So if you break an ACOP, it comes as if you're breaking the law. Guidances, however, this type of booklet is just advice from the HSE. It doesn't really have any legal standing. It's just good advice. If you follow it, you should be safe, but the guidances themselves are not legally standing, right? So there were two types of laws, right? There was statute law, and then you have the law that is not made by parliament. So the first question to ask yourself is there such a thing? And the answer is yes. You have what is called common law. And common law is like what you see when you have a judge sort of, like overseeing or have the jurisdiction then of that matter, right? So common law had a long history. I'm just going to tell you the history because this is not a history course, right? They have a long history in that the kings of England many years ago, and even before them, I would suppose Rome. Yeah, I mean, if you talk about well, I mean, it had other dynasties then that ruled parts of the world, right? Like the Mongols, if you know about that, the Vikings, which we probably could pick picture from television shows, but they were real things anyway. So we all kind of remember the stories and the history then, like Bible stories and stuff, that Rome ruled the world. And of course, for many of us who don't know, Rome is actually, well, Italy and that's part of Europe, and a lot of those persons actually made it to England. Yeah, so England, the English and the British ruled the world as well, and that could be because how people, was dispersed. A lot of like what would have been Romans actually end up being British. Strange, right? And a lot of British actually is actually Americans. Remember, Americans are not true Americans. The Native Americans are not really, well, the Native Americans are the real Americans, right? But quote unquote Caucasians and white people who like to think that they are Americans are not really Americans. They're actually all British, right? True, right? So the long and short of this is that I guess that gene of trying to rule the world has gone through the generations then, right? But the long and short of that is that even if you go further back, it's like they always had people always had problems then. So when Rome ruled the world, they ruled over different places then, right? So people always had issues with their workers, with neighbors, with loved ones, with ex-loved ones. So there were always disputes there, right? If you trace these things back to most times, even back to Egypt, right? You'll find that they were always like rulers, which today we call judges, but they were always rulers hearing a matter then, right? Between two parties, right? And so the idea of the word of a ruler being like law was always there. Today, of course, we call it, like a judge. And again, they may have said judgment back then, but I guess in the ancient days, they may have said Pharaoh or Pontius Pilate, which is actually like a position then, right? Pontius Pilate is actually not a name, but it's actually a position. It's like saying emperor. It's like saying king. It's like saying the Queen of England or the King of England, right? So what they said is that what they started to do, they started to collect those laws. Yes, from many years ago, right? They started to collect the laws to achieve consistency. What does that mean? It means that somebody must have lived on the planet before that went through what you're going through, right? If it's a water company that have a busted water line that flooding out your property, if it's your neighbor that have an animal that came into your yard and damaged your crops, if it is something like oil or sewage or whatever, something, right? Some family member fighting for land or somebody name wasn't here. There's always somebody who lived on the planet and experienced that before. So what the kings and the queens and the pharaohs and whoever you want to call it did, decided to collect that. And that's exactly what they call precedent, right? Now, if you see, they went back to Henry the Second and the 12th century. But if you go further back, like I said, remember the British, what I'm trying to say, the British built their empire on the back of the Romans then. And the Romans probably built it on the back of the Egyptians, and the Egyptians built it on the back of God knows who, right? They Sumerians. So there was always people living on the earth. And once you have people, you have problems, right? So what they did with these cases, when they collected it, they call it a precedent. So a judge today, a judge in Georgetown, a judge in Siparia, a judge in Princeton, right? A judge in Arima, this place in Trinidad, a judge in Berbice, a judge in Linden, right? If they are faced with a matter between, let's say, the water company and a neighbor or a resident or somebody who was affected by water getting into their property, what the judges today do, they look back for the old cases. That's called a precedent, right? And what they try to do, they try to rule in a similar way. If the water line was busted because of a fault of the company and it was not the fault of the resident and the water flooded their property 100 years ago, right? Yes, it had water lines in Rome. You can check it out. It had toilets and stuff, but they were actually public toilets. I don't know what you think. It's the most grossest thing you could think about. But anyway, yeah, there were public utilities back in Rome. You can check all of this thing out anyway, right? So like what they were trying to do was like if the company, or if they even call it a company, but if the entity was responsible for that leak, would the entity have to pay? And that's what precedent is, right? And there is one famous one here. So if you look at this, you'll see that. Just go back here. As the court system established under the modern kings, because we could trace it back to the modern centuries, but if you know history, you can trace it back to Egypt, you can trace it back to Rome as well, right? The doctrine of precedent developed, right? Lower courts produce persuasive precedents. A higher court decision is called a binding precedent. Change is greatly influenced by society's modern way of thinking, and precedents could change. Yeah, a precedent is a standard, but it can change, right? It changes how a generation will think. Like, for example, cell phone use, right? Like, we all kind of know cell phones may be causing radiation. Plastic used to, right? Plastic cell phones. But it seems to be acceptable now. So if somebody's suing a plastic company now, it probably mightn't make any money because we all kind of get used to that. If somebody's suing Samsung for radiation out of their cell phone, it's probably not a thing now. It's not a thing, right? But in years to come, if it was found out that, that the radiation from the phones is causing XYZ, like they'll have massive lawsuits that, and if it becomes a thing, it becomes a precedent, right? So cell phones then cannot be found in the old precedent because they were not cell phones 100 years ago. So, as technology changes, if there is a deciding case, then that changes. Well, I can give you one. I don't know if you all know one. There's one about Johnson's and Johnson's baby powder. If you all have heard about that, the talc, TALC, in Johnson's and Johnson baby powder is responsible for causing cancer. Now, if anybody takes up a case, sorry, against Johnson and Johnson, they would win because this is since the 80s now. It have precedent cases and like millions of dollars being paid because the story goes that Johnson and Johnson had known about that. They just never do nothing about it. But my question is, right? Okay, like that was in the 80s, 90s, right? So my question is, in the 60s, 50s, 40s, 20s, 30s, were parents not using powder on babies? But if they had decided to sue Johnson and Johnson, let's say in that time, then nothing would happen because it's not a thing. So then it's known today, society, modern way of thinking that Johnson and Johnson baby powder, the talc, is cancer causing. So 20 years from now, it may be known that the radiation from your cell phones is causing cancer as well. For now, it's not a thing, but precedent could change, right? So there's one in your course if you want to go look at that. Oh, sorry, let me just explain one or two things here, right? So a common law involves a dispute between two parties. Yeah, but it can't be suing yourself, right? So normally the employer and you, brothers, family members, especially where house and land is concerned, water companies, electricity companies. So there's normally like two parties. The burden of proof is on the claimant. The claimant is the one that made the claim. If you said, well, to the employer, well, you owe me a duty of care and I was injured and I'm suing the company, well, you are the claimant. If it's a neighbor, the neighbor got something in your property, you are the claimant. The one that's claiming is called a claimant. And the matter is referred to as a tort. None of this is exam. Remember, I tell you, this is sad news about today, folks. I will say it a couple of times, but I said it at the top of the hour. There is no past paper questions. If you get one, we'll be very happy. But it have nothing to go back to then to say like, this is our question came. There's nothing like that, right? But the word here, once you are in disputed someone, that is well a civil matter, right? They call it a tort. Tort is actually a Latin word that means wrongdoing. And if you win your case, you are normally compensated by the wrongdoer. You don't, the person doesn't go to jail. If it's the employer that you sued, you would win money. If it's your neighbor for property damage, you would win money. If it's a loved one or ex-loved one, you probably would win whatever you're suing for, if it was the house or the land or whatever. Well, if it goes in your favor, I have realized a lot of cases in Trinidad where family members are considered judge rule in a sort of joint way. So like if you feel you're going to win everything, you don't. If it's brothers and sisters, they award the thing to all the brothers and the sisters, right? Which makes it even worse. right? But that's how it is, and I suppose the judges are doing that because of precedent anyway, right? If you have a claim to make for wrongdoing, you have 6 years to bring up that person or company. What is tort again? Tort is wrongdoing. What is a wrongdoing? Somebody did you an injustice, right? And if you stick to occupational health and safety, that could include being fired, that could include blocking your promotion, that could include victimization. Tort, in a tort, then you were not injured. You want to write it down? In a tort, you were not injured, but you suffered wrong, like they breach your contract. Just take a, it's not an exam question. I'm just trying to explain it here, right? In a tort, so that's why you have 6 years now because you're not physically injured, right? But you have 6 years to bring up the entity. So what I was saying is like a utility company, WASA in Trinidad and Tobago, the water company in Guyana, whatever company it was, if there's some damage to your property now, it's like you have 6 years from the date of that contractor, notification, if you could see what the problem was, to bring up the company, right? If it's an injury, which we could come back to companies now, if it's an injury, somebody fell, got injured, you have 3 years to bring up the company. If 3 years pass, it'll be difficult to sue the company, right? And so, um, if you wonder why 3 years, like why not just a short period of time? Well, there are some people that don't believe in suing, and you may have been involved in a workplace accident, but it didn't dawn on you then, right? It didn't dawn on you to sue the company. The pain wasn't that bad, right? You got impacted to your back, and you were okay, as most men would normally say. But I'm talking to the men, right? Most men would normally say that they are okay, right? But the pain there, and you didn't say nothing, and then 6 months the pain get worse, and another 6 months you went to the doctor and they realized, okay, you have a slip disc. This is actually a true thing I'm telling you, right? So then you still don't know what to do, and then you come into a class like my class, and you hear somebody say, "Well, you have 3 years," and then they say, "Okay, well, can I bring up the company in court?" The answer is yes, right? And I have many such cases. I don't want to tell you all of them, but I could tell you one, right? One was against Price. I think Price Mart is in Guyana. If Price Mart is not in Guyana, Price Mart is like a Walmart. It's like a huge wholesale distribution center. We have a couple of them in Trinidad. It's kind of like KFC. Anyway you could go in one of the bigger towns, and you could find a Price Mart in Trinidad, right? Um, I think somebody had mixed it up a time and thought it was Macy's because it's like that. It's a kind of big kind of store like that, right? Anyway, I had a student whose girlfriend was one of the persons at the Travelator, the base of the Travelator in Price Mart in Laramie, and she got impacted with a trolley that damaged her back. And they didn't know they had a case, and her boyfriend was in my class. And when he heard the same thing, of course, I didn't share their story. I shared somebody else's story. I shared another story of a tea and tech worker, right? And electricity for like Guyana power and like that, right? But for those of us in Guyana. But I shared another story. When they heard that, they got on to me, and the long and short of it is that they actually won a lot of money, more than, well, I can't tell you the amount, but close to like, no, I actually wouldn't say it, right? But they won a lot of money, right? But the thing was that this lady had genuine injuries. For about a year, she was suffering that pain. And that is just one story of many that I could tell you, right? So what I'm telling you is that a lot of people don't believe in suing at first. They bear the pain. But if you know you have a case, then you can sue, and it mightn't help the pain, but it may help, taking care of the pain anyway, right? So all of these things are pretty common. Like criminal law is laws made by parliament, civil law is law made by a judge. Criminal law, the purpose is to punish. Civil law, the purpose is to provide redress. Redress is justice. You kind of get justice for the wrong that you suffered, and the justice is in the form of compensation. None of these have ever been asked. However, if it was asked, you all could just pull this table and get it. There have never been any questions like this anyway, right? I want to take a look at a slide. I have somebody at the door. So let me just give you a look at a slide here. And we're coming back to this main slide here, right? So you could have a read of this. Just give me a minute to check who's at the door and I'll get. All right, thanks for your time again. So what this is, right? So normally when you sue somebody in a civil matter, it's referred to as well, like the matter is referred to as like somebody would have been negligent then, right? So there's a definition for negligence here. You could have a look at it, right? This you could even write it, yeah. They say negligence is was defined by a judge, right? Of course, they would have said, like in the UK, they say Lord, right? Lord Atkin in 1932 as a lack of reasonable care or conduct that results in the civil wrong. So that could be any part of the employer or I guess a loved one, right? As a result of which a loss, injury, or damage is incurred. And what happened? There was an old case here, as we spoke about precedent. There's an old case here, right? Where a lady, right, Mrs. Donahue, was out in the bar. Well, that's like a common thing, right? I mean, and that's very common in the UK. That's what they do. The bar scene is not quite Trinidad bar scene or Guyanese bar scene. I was actually in one of them, and you'd be amazed, right? On the evening, uh, workers will come in jacket and tie, right? Like the bar scene is kind of different. It's not the kind of, what we say bacchanal then, right? Anyway, so she was having a beer at the Well Meadow Cafe in 1920. The beer was in a opaque bottle, sort of like a Heineken bottle. And it was opaque. No one noticed it had a snail on it. And she consumed this bottle with the snail and she got sick. Most Trinidadians or Guyanese may just, you know, forget that and buy another beer. But she didn't, right? She actually sued the company and she won her case. And coming out of that is where they got the definition of negligence from, right? The judge, the judge said here that the beer company was negligent towards her death. And if you understand this, like if we know the word negligence today, this is where it was defined. This is where the definition first came from 1932. A judge in the matter said that the beer company owed the lady a duty of care. If you wonder why, he said in a way, she was like a neighbor to the beer company. You wonder how is that, right? How is she a neighbor? I mean, she's not living by the beer company. Well, what the judge said was that a neighbor is someone who is affected by your actions. So, like if you have an animal or you have water, oil on your property and it gets into your neighbor property, well, you are affecting your neighbor. So, in a way, the beer company, what they had in the bottle affected her. And if she got sick, well, then somebody have to be at fault because it can't be her. It had to be the one who made the beer then, right? And anyway, because of that, she won her case. Watch it here. Mrs. Donahue won her case. The judge, Lord Atkin, neighbor principle, that people must take reasonable care not to injure others who could foreseeably be affected by their actions or inactions. So that case, a simple thing like that, went down in history then. It became the precedent. So today, by the way, this was in Scotland. Remember, Scotland is part of the UK. The UK is England, Scotland, Wales, and Northern Ireland, right? So this is in Scotland. They have a memorial to her because I mean, imagine that. It's like you get a memorial because of suing a company, right? So like they have a memorial to her because today in 2024, doesn't matter if you are in Trinidad, in Berbice, and Georgetown, and different parts of those areas anyway. If you had purchased something that was defective from the get-go and something happened to you and you sue the company, you would win. You would actually win because of her, because her case went down as a precedent. That's what I said the judges do. The judges, they look back. If you purchase then a banks in Guyana, or you purchase, I guess, a Caribbean Trinidad, or whatever, right? And there was something in it and you didn't put it there. Maybe you have a video running, maybe the CCTV footage is running, and you could like when you open that, you see like something in it, right? And it wasn't you who put it there, and it's on you, you would win your case. Once the judge here, once the judge here, let me just call somebody name, right? I call it somebody name from class, right? Like once the judge here, Savita versus Banks, the judge will know that case, because remember, lawyers are learned people, right? We are not law. This is not a law course, and we're learning about laws, right? So once you say Savita versus Banks, they don't know that's Donahue versus Stevenson. If you have the CCTV footage to prove it, when you open this thing and something came out of it, like a worm or something, or some insect or something was dead inside it, right? But you have to consume piece of it because you're seeing a bit, you have to be affected to actually win your case. Like how she got sick, you have to win your case. Well, you have to prove injury or loss then to win your case, right? So, like I said, Trinidad too, if it is, Al Jerome versus SM Jalil, right? And again, you have a same similar setup. Well, you'd win your case because everybody knows Donahue versus Stevenson is the modern. When I say modern, I mean this is modern because remember this thing goes back centuries anyway. But this is the modern case then that was taken in to be the precedent for consumers and suppliers. Do you all understand it a bit? And I'm not just telling you, I'm not just, I could tell you, I have students that actually do this. Three of them, in fact. I could probably just give you one story. Students of mine who were in the class, yeah. I had a student, his name is, because it's not was, I mean, he's not with me anymore, but Sterling is still around, Sterling Shade. A guy that opened a pack of peanuts had found glass in it, right? And he had just done, one of these things that was fresh in his head too. So he sued, I think it's a Sunshine Snacks, and he won. There is no doubt, you see. Once there's a precedent, that's what a precedent means. Okay, a good way to think of a precedent is somebody pass and cut the grass for you already. You don't have to cut it. The grass done cut. You just had to walk. That's what a precedent is, right? A precedent is if you have a case and it like you have a matter with banks, so you have a matter with SMG Lille or Carib, and it have Donahue versus Stevenson, it means that the system of compensation has already been established, right? So it makes it easier for you then. You understand why there's a memorial to Mrs. Donahue? I really want to go and see this. I'm going to the UK in December, the 6th of December, but I'm not going to Scotland. At least, I could, it wasn't part of my plan, but I probably could change my plan. I was planning to go France, but from England, if you didn't know, you could get a train, and the train goes under the sea, and you come out in France. Yes, you can check it out and see, right? I was planning to go France, but then I kind of changed my mind about going France, so maybe I could go Scotland, or if not next year. I wanted next year, though it's kind of harder to get to the UK. For those of us who know they're putting in some measures in place. For Caribbean people, right? It is going to be a bit harder to go. Today, you can just book with a passport for the now in December if you have a passport and you can go. But be a little bit harder next year. So I don't know what the requirement will be. It's not a visa. They're not asking if a visa, right? But it's some things you have to prove, like where you're going then, right? For now, anybody could just pick up and go still. Trinidad and Guyana, right? Both countries, Trinidad and Guyana, we have that privilege where we can just go to England without a visa. Americans have to get a visa to go to England, right? So I would probably want to go and see this. Maybe if I take a picture, I'll probably change this picture and I'll put me standing up next to it. So, because I don't feel I'll be able to go back. I don't know what the restrictions is some next year, but we'll see when the time comes, right? Anyway, we're moving on here. So there's this, you understand the importance of this, that it's not just here, it's here for everybody. It's here for everybody to benefit. It's not that Mrs. Donahue is somewhat special. She's only special because, I guess, of what she did. And because of what she did, a lot of people who are injured or affected by manufacturers have a chance of getting some kind of justice then. So I think her memorial is justified, and I guess kudos then, to her for being brave. Because a lot of people would not have done that. I myself would not have sued a company for one beer. I would have just bought a next one. But everybody's different. Everybody's different. And because of her actions, the world benefits from that, right? All right. So this slide here is what I told it. I may have asked her to write something for me, but I guess I could explain it first and then we could try to write it. It's actually not to write, it's to draw something. So what we were saying is that a court case then, right? Or a case is against two persons. So I could draw it like this. I'll draw it like a seesaw. But I'll draw it in a way like the employee winning the case, right? So I'll draw this side as higher, this side is lower. You can draw this. You'll see what this is. So this is the employee or the claimant, right? This is called the claimant, the one that's making the claim. Right? The employee. That could be you, and of course, this doesn't, it don't have to be an employee member, this could just be a family member, but whoever making the claim, a neighbor, you call a claimant, right? So now why I draw it as a seesaw for is because um it's like two parties there, right? A court case is like a battle. A court case is like a battle, right? Where you say your side and the other person say their side. Think you understand? A court case is like a battle. If it's like two neighbors or even family members, right? It's like you have to say your side and then the other side have to say their side. You must have seen a lot of television shows like this. If we had seen which we all did, the trial of Johnny Depp and Amber Heard, right? You'll see it's like a battle, right? Now, for you to win your case worldwide, this is what you have to prove. You or your lawyer. This is what you have to prove. You have to prove that a duty of care was owed, right? You have to prove a duty of care was breached. And because of the breach, you have suffered injury or loss. So that's what I'm saying. Is like in the case of the bear, Mrs. Donahue had to become ill then, right? But it's not just injury, it could be loss, right? If you could prove the loss, like for example, like if you were wrongfully dismissed then, in that sense, you're not injured. But you could prove the company owe you a duty of care because you are their employee. You can prove they breached the duty, perhaps if you have a contract. And if you had the contract, let's say you had a year contract, right? So the contract was running for a year. I'm just making this up. Let's say you were getting 7,000 TT dollars for the month. So that's 72,000 for the year TT. If you could multiply by 30 something, you'll get the Guyanese equivalent, right? But if your contract is breached halfway there, it means they have half year salary for you. In that sense, if you don't sue them, you lose the half year salary. You're not injured. You could go and find a next work, and 10 to 1, you are getting another work. But you could still sue the company because they breached your contract, right? So the three things you had to prove is that a duty of care was owed, which could be proven if you are their employee. Duty of care was breached, and that could be whatever it was not safe or the breach of contract. And then you have to show the injury or the loss. As in the case of the girl in Price Mart, I try to remember their name. Some years ago, it's before the pandemic, right? Can't remember the name, right? But in the case of that, situation then. She had a medical bills. It was as if they were faking. She had, in fact, they didn't know they had a case now. They didn't know. Let us say they were she and her boyfriend, because the boyfriend that did the class, and then I got to meet her and stuff, right? But they didn't know they have a case then, right? But you know, what I mean by that is that she was seeing about her own medical bills, and like a year into the thing, she was paying her own doctor, the slip disc, she was taking her own whatever. They didn't know about the concept of suing, right? But in that case, that when they did decide, she had the medical bill, she had the X-ray, she had the slip disc, so it was not difficult to prove negligence, and in that case, she won her case, right? So what I was saying, I mean, this is an open book exam, so you don't have to really learn these things. And again, for the third time today, this is such a nice thing. I don't know why NBOSh not examining this part of the syllabus, but they are not. The bottom line is that they are not. There have been no negligence questions, right? Can I get to the next slide? So what do you see on the next slide? The next slide have, so if you want, I can write it here further, but it's here already, which was I didn't write it. If you want, I can just write the word. The employee have to prove a duty of care was owed. This is giving myself double work, right? Because it's on the slide already. Owed, but this is what I wanted it to write. The duty of care was breached, right? And that they did not do this or they did not do that. They did not provide PPE, right? They did not provide safe access egress. Um, and because of the breach, you have suffered an injury or a loss. I don't know if I told you this. I sometimes tell the classes the same story, so I don't know if I told you this, but I'm actually what you call, well, trying to rephrase this. Okay, like in a legal matter in Trinidad here, the court have asked me to be their expert witness in a case when an employee he did slip and he did fall now, right? He slipped and he fell. And the company was saying they did everything they could have done, but they didn't do what they could have done, right? The thing is they had the man, well, the workers that were walking on pipes. So yeah, that's what they did for the last 60 years. Like, yeah, they walk on pipes, like a pipe rack then, right? And it was 1 o'clock in the morning because of a night shift, and the guy fell, right? But walking on pipes then cannot be safe access and egress. There's a way to walk on pipes. Yeah, they put like a step. Yeah, they put like a barrier then, right? Like a mesh with double fencing on it so that the guys could walk on that. So you can walk on pipes. People walk on pipes all the time, or we have pipes. But walking on the physical wrong pipes then is not safe access egress, right? Anyway, but in that case, there is actually a physical loss too, right? He have his medical, he had to have knee surgery and stuff, and he would win his case, right? On the other side of what I was saying is that the employer now have their side of the story. Remember, there's a judge, like Judge Judy, if you want, I could put a figure up here for you, put a face up here, right? So you know that there's a judge now listening to what is being said. It's not that it's not that everything you say would be taken. I don't know if you all have seen like some judges, they would just strike it from the record, or they would not just consider it because it's kind of not making sense, right? However, again, I'll go back to the idea that in a court case, it's like a boxing match, right? So you are on this side, the employer is on the other side, and the employer is free to fire a jab then, but it doesn't have to hit you. Meaning the employer could use all of these defenses here, but it doesn't have to be taken into consideration, right? How compensation works, or how common law works. If you want, I'll go back and I'll show you. Um, the purpose of this type of law is not to put people through hell, right? The purpose of this type of law is to give compensation to the injured party. I don't know if you want to write that down. We could go back here, so it's on this slide. Let me go back and I'll share, right? When they said justice, when you go back straight up, right? When we go back and we see here, the purpose of this type of law, right? The purpose is to provide redress. Redress is justice, right? So the purpose of common law or civil law is justice, but justice in the form of compensation. So what I'm trying to say is that not because the employer defended himself or herself or the company self, it means you're going to lose. That's just the boxing match. Not every job would hit you that, right? The judge sitting here, if you have a genuine injury with genuine medical bills, you will win your case. Again, listen to why. The purpose of this kind of law was not to go to court. The purpose of this law is to give justice to the injured party. So if you are injured, if you suffered loss, your property from the water company or the power company, utility companies, if you suffer loss, you will win your case, right? Because that's the purpose of the law, is to give you justice, not give the employer justice, give the injured party or the party that lost justice. Folks, you think you understand that? So having said that, though, let me read you. All of these are the employer's defenses. You can think of these as the employer defending themselves in a boxing match, but not every cuff that they, or not every strike that they hit at you would actually hit, right? Because this type of law isn't really set up for them. This type of law is set up for the injured party. So they're already in a losing battle there. They're already in a losing ring, right? So some of their defenses, they can claim that you contributed to the accident. Some of the defenses they can claim is they say that you willingly accepted the risk. There's a Latin phrase for that. It is pronounced volenti non fit injura. It means to the one that is willing, no harm is done. I can give you examples of them, but remember, there's like zero questions there, right? So that, like that second one, it's sort of maybe there is something on a height, and the employer tells you, look, we have to get that part. That part is the missing part in a component for a pump. Now, if we sell these pumps, each of these pumps is 100,000 TT, about 3 million Guyanese, right? Or probably more. I have a calculator, right? Probably more, it's about 30 million Guyanese, right? I think, right? So the employer say, but right now we don't have, like a scaffold. It will take too long if the client is waiting. We need to sign off on this contract. If we could tell them we're giving them this part, we're gonna get, $100,000 in sale, right? So the employer says, but the part is way up there. We can't get it. It's stuck so high. And then you say, well, don't worry, I will go up. I will climb up on the forks of the forklift. You'll just raise me up, right? The employer said to you, and this could be a good company. They say, well, if you fall, we can't accept liability. So that's what this point is trying to say, willingly accepted the risk. To the one that is willing, the law or the phrase then sees it as no harm is done, right? To the one that is willing, no harm is done, right? However, that's actually not true. Remember what I tell you, this is just a strike. It's just a possible job that the judge could just throw that out in the matter. Because you see, once you're injured, remember what I tell you, you will get money. Once you suffer loss, you will be compensated. Even if you said, okay, I will go up. The thing is, anybody remember, could I ask you all if you remember something? Do you all remember section 2 of the HSW Act? 22A, 22C? What I tried to show you a contradiction. The employer could be trying to say, well, you willingly went up there. But that's not true because the employer have a duty to ensure that the employee is safe. The employer have a duty to say, so if the employee said, I'm going up, and yes, they're studying money, the thing is, Section 22A of the HSW Act said the employer is supposed to provide safe plans and safe systems of work. 22D, safe access and egress. Climbing up the frame then of whatever your packing material was, that is not safe access and egress. So in a way, if the employer is trying to say, look, you willingly decided to go up there, the judge could be thinking, well, yeah, But the thing is, you broke the law, you broke the HSW Act. You should not have allowed that. You understand the contradiction, folks? Tell me if if you understand the contradiction. The employer is trying to say that you willingly accepted the risk, which may be true. You may have volunteered because you know the company wants to make money. The employer just explained to you, if you get this part, you'll get this is a true story I tell anybody. Way. I tell you the company afterwards, right? So like $100,000, but like a seal for the pump missing then, which is the rubber. And if the seal missing, the pump is no good. So you need to get the seal, right? So you understand the contradiction. In the event of a court case, the employee now suing the employer. The employer can say, well, look, you, Frank, you volunteered to go up there. But the judge could be thinking, well, yeah, he volunteered, but the thing is, as the employer, you have a greater duty to the employee to provide safe access and egress. So taking the job then, right? Taking the lines here I was telling you all doesn't mean anything. Judge Judy, which is not really the real judge here, but Judge Judy, right? Or the judge in the matter in Siparia or Arima or Berbice or Linden, Georgetown, the judge is going to pick sense of nonsense. The employer can't say you willingly accepted the risk, but there's a law saying you're supposed to provide, you're supposed to make sure the place is safe. Think you understand the contradiction? Anybody knows what is section 22C? Anybody remember 22C? If did you all write it down? Yeah, you probably should have. It's in the same PowerPoint, but I don't want to turn back. I want to see if anybody reading this stuff, internalizing this stuff. Anybody know what's 22C of the HSW Act? 22C because in a way, the employer is actually breaching 22C as well. Anybody knows what section 22C is all about? The company is supposed to provide what? Even if you volunteer to go up in a hazardous situation,
Training.
training. It have a next letter there. It starts with S.
Training and supervision.
Supervision. So how could you, as a safety person, as a secure company, see a man climbing up a frame of a stacks of material then, right? That's not proper training. That's not proper supervision. So in a way, you're lost. The judge don't know you're lost already. That's what I'm trying to tell you, right? I was trying to tell you, I was trying to give you the idea that it's kind of like the Johnny Depp thing now. You remember Amber Heard, which was she starred in Aquaman. I saw the reason Aquaman was actually good. I actually saw that in Guyana. I fell asleep too. For those who know me, please don't laugh, right? I have if I want to sleep, no, I sleep pretty well, but I do a lot of work, right? But like if I want to take a good rest, I go to the cinema. Yeah, strange. I go and take the best sleep of all at the cinema. I pay for the ticket. I pay for the ticket. And I will sleep and I will get up and the movie will still be going on. About the good part. About the good part. Sometimes I pick the most boring movie just to get a good sleep. Yeah. So I think I saw I think I saw Aquaman in Guyana. And then I did see Bad Boys. That was actually good. Bad Boys is in Guyana. I saw that in Movie Town. I saw that about after 12 a morning or something, right? But yeah, I have a kind of thing for that, right? If I'm tired, I don't want to take a good sleep because like if I stay in the office or if I stay wherever I'm in a hotel room, I'm gonna get work done. So it's easy way this thing, right? But it works for me. I take a good rest. I get up, the movie's still going on, get something to eat, travel back home, etc. Anyway, yeah. So strange. All right. So you understand the thing about the judge and there's still a judge and the employer cannot just say what they want to say. It is kind of like that Amber Heard thing I was telling you all about where Amber Heard tried a lot of defense. Well, not defense, accusations then. I think Johnny Depp was the defense, right? And it didn't work, right? So not because she had pictures of being struck in her eye. Anybody remember that? She had pictures of where he hit her, but it wasn't. It was Photoshop, right? So now because you say something, it means it will be analyzed and there's always a judge. It's called a judge for a reason, right? Let's say again, the employer can say the risk was not foreseeable Now, that happens a lot for natural disasters. If you're suing a company, I mean, Trinidad this week had some severe flooding in North Trinidad, right? But like if you had your vehicle, which we did see people vehicles park and you know got moved with flood waters and got damaged. If you're suing a company, um, the company can say, well, what happened was not foreseeable. Like that part of Port of Spain, which is a joke, right? Never flood. But it may be that your company is in a part of Port of Spain that doesn't flood. Like water never came up there, and it's like something had to go wrong. Something, and of course, Guyana does have a lot of flood because it's kind of under seawater as well, right? But if you're part of that company that never flooded before, so they had flood. You heard about flood in Albert Street in Guyana. We heard about flooding on uh, well, anyway, like the whole of, I mean, but in what's the name of that street? Edward Street, right? Edward Street in Port of Spain, Albert Street in Guyana, right? But let's say like Edward Street, for those who know where it is in Port of Spain, always floods, right? But if your company was there, but it never really flood on that higher side of Albert Street now. Sorry, Edward Street, right? And it did, right? It did. Like your company did 60 years and the flood is always kind of lower down. And it did, the employer can say, well, the risk was not foreseeable. Again, the judge can say, well, if the lower part of the streets are flooding, it may be reasonable to think that one day will come, if it's one day in 60 years, that the flood is that bad, right? So it's up to the judge, right? It's up to the employer or Amber Heard in that case to produce the accusation or the job. It's up to the judge to listen to it and to make sense out of it, right? As I was saying, if you go back and study and realize that is what happened here, right? Um, the judge though took Miss Donahue's side, Mrs. Donahue's side, right? Mrs. Donahue won her case, meaning the judge took her side. Lord Atkin went on the neighbor principle, so the judge took her side, right? Some further defenses of the employer, they can say the duty of care was not owed. If you realize what they're trying to do, they're trying to deny
Sir,
everything you say. Yeah, go ahead.
what about in a case like if it is the employer then send you to do to get the rubber thing and you went and do it on your own?
Um, they could say that yeah, well, what just one here? This one here is like that one. You're out on a frolic of your own. You did something on your own, right? Um, However, Nisha, right? What if you were injured in the company's property, like on their compound, the company still have a duty of care to you. Once you enter the compound and you sign, you enter, or if you're on the company's work then, right? If you're in the company's job, you're in the company's work, the work could be the workplace or the work task itself, right? You say that the person did something on their own. The truth is, if it had a supervisor, they would have not done something on their own. So in a way, the company still is at fault, right? But what could happen, right? In some cases, what happened, the amount of the compensation will be reduced, but you will still get money, right? Remember what I said, this court system is set up to compensate people who suffer injury or loss, right? It's not set up for the employer, it's set up for you. You will get money, it's just how much, right? I'm thinking that one could be a case of frolic of your own. But what I'm saying is that there's something on the other slide. I don't know for me to go to it as yet, right? I could go to it and show you. There's something on the other slide. It's called vicarious liability. Look at it, right? So what that is, if you want to, let me explain it, right? If you read it, you still mightn't get it. But vicarious liability, a good example is like parents, which we all have or had or are or will be, right? If you remember being dropped to primary school or you are dropping your child to primary school, and then a few hours later you get a call that your child fell down, or you come and you see the child in a mess then, right? What I'm trying to say is that listen to this story, right? That the child is the one who may have run and fell. But in a way, in your mind, who are you who are you holding responsible for that? Your child fall along in school and break their hand. This is a
And the
true thing.
principal.
Right, you're holding the principal and the teachers responsible. You understand? So Anisha, the concept of vicarious liability is that once you're in the compound of the company and you get injured, the company responsible. Right? It's like once you drop your child in school, in your mind, the principal responsible. So like once you enter the gate of your company, the company responsible. It doesn't matter if you are now there is a famous case to that, Anna. Remember these things are not written here for joke, right? Like how we have Donahue versus Stevenson. There's another famous one. I don't know if I can remember the proper name of it, but I can remember the story. It's a story of a man who was trying to catch a bird in a company. And the bird went up like where it had a revolving cog, and he put a ladder on the revolving cog to try to get the bird, right? He fell. So what I'm saying is that what he did there does not work. He was trying to catch a bird. But the thing is, he was in the company. So if you read the line, it says an employer will be vicariously liable for the negligent action of employees. Who is doing the negligent action? Who is trying to catch the bird? Who is running? Who is horse playing? It don't really matter. Because once you're in the company compound, this concept is that the company, the employer, the manager is responsible for you during the course of your employment, right? Now, if the company can prove like you were not in your employment, the compensation claim may be reduced or you may actually lose your case. That happened to me. I could give you the story. It's a quick one. Right? I remember some years ago, I was working for a company called IAL. IAL is still around, and well, they're part of Tucker, and I've seen them in Guyana. Yeah, they opened a big branch in Guyana. Schlumberger, a lot of people that's heading across the Guyana. Everybody there, Junior Sammy, Pusals, IAL, everybody there, right? Um, so like try to see how much I tell you. Yeah. So like in that company, we had a delivery to make to Point Fortin, which is like about an hour drive from those who know where IL was in Cross in San Fernando, right? Anyway, I was just a junior technician, folks. I was just out of school and whatever. I was a pump technician. I told you that I didn't always study safety. We were repairing a sort of pump called a PCP pump, a progressive cavity pump, right? It's a huge pump. It is like a pumping jack, if you know what a pumping jack is. It's like a pumping jack without that part of the pumping jack there, right? There's like a pump that suctions the oil from oil wells. Anyway, so we were going to drop a delivery in Point Fortin, and the driver, which I wasn't the driver took a shortcut, passed through somewhere, Lawton Village, for those of us from South Trinidad, Lawton Village, and ended up what looked like a old, well, not that old, but a shack, right? So when he stopped, I mean, I was just a junior technician, right? When he stopped, a child ran out from this place and said, "Daddy," but I know this man that, that wasn't his, at least the mind knowing anyway, right? So anyway, coming out of that, like we did have a minor accident, like leaving that facility, another vehicle kind of made contact with our vehicle, with a company vehicle. A lot of it was because of reckless driving too. But the thing is, in that sense, then, right? I'm saying nobody sued anybody, but if somebody had sued, what could have been proven then was that the employee was out of the course of his employment, right? He was not, like, we were not where we were supposed to be. We were by somebody's house, by somebody's shop, right? So in a case of that, that could have been thrown out anyway. But other than that, if we stick to the example from Anisha, if you're in the company property compound, yes, you may not be doing what they asked you to do. Maybe your job was like me, pump technician, but then you went down to the stock room. But stock room was like you're on your own. You probably went to smoke or something, and something happened. But the thing is, you're still in the company's property. So in a way, you are still like that child in primary school. The principal is still responsible for you. And in the eyes of a judge, if the employer was to say, something like that. They get out in a frolic of your own. Well, the judge can still say, well, true, but this happened in your compound, right? Right. The last one, the time to make the claim has passed. Anybody remember how much years? I had said it on the slide just.
You said
Yeah, just if you answer my question first, anybody remember how much years you have to make the claim if it's an injury?
Yes.
How much
yes.
years? 3 years,
3.
very good. Okay, thanks very much. Okay, first question. The first person that said something, I'll take them first.
I was gonna ask, so I know you spoke about being on the compound, right? But seeing as you was a junior tech and the person was a driver, if you were injured by driver's negligence, that is also considered um vicariously liable to the company
But,
if you got in an accident.
but is
Because
this
if you
driver
want to,
is this
but
driver
if
from another company?
oh, from the same company, so it's you
Yeah,
and
yeah,
the driver
same.
from the
Yeah,
same
yeah,
company.
same thing. Yeah, yeah, yeah.
So that is an instance of being outside of the actual company, but still in a company vehicle.
Yeah.
So
So you're
it's
still
still
in the
being
course of your
vicariously.
employment. Yeah, you're in the
Right.
course of your employment. So that's the thing. So what I say, the course of your employment could be physical, like the compound. But if you are delivering, if you are a delivery company, right? If you are delivering, bread, right? Cakes, pastries, Bakewell, of course, in Guyana and Kiss in Trinidad, right? Yeah, if you're in the course of your employment and you're injured, but then the company is still responsible, right? Yeah. Now, what I'll say, Aldrum, these things have to go to a court. Well, actually, no, that's not true. It have to go before a judge. A judge is not these. Okay, okay, like Judge Judy, you all may have seen, is not, like there's not a jury there. It's just like three people. It's like you, the defendant, and the judge, right? So, when I say court, don't think of it as a big courtroom. Sometimes it's just three people there. You're a lawyer, company lawyer, and the judge, right? So the judge will hear the matter and sort of give a judgment, kind of like what they do in Judge Judy. Judge Judy is kind of more for television, though, so some of that is not always the way it is in reality. There was somebody else that had another point. I think I heard two voices. I'm not too sure.
So
Mhm.
I work in a company, right? And the other worker lost part of her finger. And the company didn't want to give her anything.
How long ago?
But, oh, last year.
Sent you by me?
No, this, is that last year or this year?
Yeah, yeah. Call me on Monday now. You still have enough time.
But we have a we have a unionized company, but it's the matter didn't even went anywhere.
Not as strange. The unions will take up your case for you and fight a case for you.
Well, remember it's a process too, and it don't look like it's going anywhere at all.
That's strange. Unions is normally fight the case and win the case, right? Everybody could come on Monday. I could see what I could do for you anyway, right?
All right.
But if a union is involved, very good. If the union not doing anything, change the union. It has some union that just waste time and money. $100 they paying for the year.
We can't change the union.
Can't change the union.
No, remember that's a union for because it's manufacturer, it's factory type workers, so that's a union for that department basically.
Yeah, but
So we can't really change
I
union, so we can't no other
I mean,
union
like
for that.
losing a finger, you're getting real money for that. You're getting more than
No,
half
she
a
didn't
million
lose a
dollars for that.
finger, She didn't
What it
even
was?
lose a limb. She lost like a limb piece, a piece of it from the machine, a piece,
Still,
like
from
half a
a machine.
nail.
Yeah.
Yes,
Well,
a blade.
here the good news. Well, I mean, here the good news, right? The law for machines and getting cut and amputation and stuff is a law called pure. I don't know if you understand what I'm trying to tell you, but the law is an absolute duty. Absolute duty means the employer doesn't really have a good defense. I don't know if you want to read. It's actually on my slide, and there's something called an absolute duty. They have no questions on it, though. If you read the slide, you'll see the word. Some laws have an absolute duty. If a law have an absolute duty, you're in luck. What that means is that the employer don't really have a good defense because the employer must do, look at here, pure, right? This is something maybe we could use. Every employer shall ensure that effective measures are taken to prevent access to dangerous parts of machinery. When somebody get cut or whatever have you, or lost a part of your finger, That's an absolute duty to safeguard the machinery. If you don't understand it again, watch it. Second point says it. The employer has no defense in court. These things that I show you wouldn't stand up. Because if what happened and all machines, if they were not guarded, if they were not protected from cuts, like how that person got cut, it's an absolute duty. The reason why I can tell you this is because of another court case that I am familiar, but I kind of dealt with as well. But it's kind of strange. I don't know if you want me to tell you a part of it. It's really strange, come to think of it. But in a company, I don't know if I ever tell you this. I ever tell you that students is use knowledge for the wrong reason. I have 3 students. I'll just tell you one. Not nowhere, but remember teaching more than a decade now. Al Jerome probably know me beyond that as well. Right? This year making 15 years in me. Well, I'm in safety. Right? And then Al Jerome knew me in my last incarnation as a maths teacher. Yes, when I left school, when I got my 11 results, 19 years, when I got my 11 results, the school asked me if I wanted to teach. I collected results, them asked me if I want to teach. I was like, yeah, I want to teach. Started teaching chemistry, biology. Of course, I went on to a couple secondary schools. I taught maths and stuff as well. But like I said, it was in the younger days, 19, 20, 21, 22, all those years anyway, right? Starting from 19 years teaching secondary school, right? Anyway, what I was trying to say is that I was telling you, I have 3 students that they have been in my classes and they use what I tell them. Some of them use it in a good way, like the price smart person. That was a genuine injury, right? But listen to this story, right? I could only tell you one. I could tell you 3, but I'll tell you one. I had a student, Anisha, right? Who purposely went after hearing the information I talk about here that a company have an absolute duty to safeguard machinery. He went and he lost a finger in a company. Now, when I spoke to him, he told me he did that on purpose. As I tell you, there's a weird story. I didn't say weird because I wanted to say weird. It's a weird story. The guy told me he did that on purpose because he researched it and he realized that all machinery must be guarded, right? And if you suffer loss, you will get money. So he said he did that to get money. He confessed that to me. He did it to get money, right? I'll stop the story there because I'll tell you it's a weird story. And he did win money. The company,
So,
I could tell you the company name and the company was I think was TCL, right?
so can I ask a question, please? In reference to her friend. So let's say, as we know, it's 3 years you have to actually present a case. Well, you have that time before you could enter. But let's say it's 6 or 7 months since the incident happened to her friend, and she didn't file anything, but the company on their own went and secure the area, knowing very well that somebody else could get cut. Is there still, can she still pursue it?
Yeah, yeah. Well, the other thing is, again, most companies don't do anything. Even the guy, like if an accident happened and somebody got a cut, most companies would not have secured that machinery. 10 to 1 that machinery is the same way it was 1 year ago. Yeah?
And,
No?
and
Did they fix
one
it,
of
Anisha?
It have plenty instances such as a big factory, but it had an instance where a fella, his hand got stuck in the machine because he take off the guard. And they didn't
That's,
want to surprise it because they didn't
that's an
want it to
absolute,
mash up
yeah,
the people rollers. So we, as because remember we unionized, we were advised to take pictures. The next day after the injury, to put back up the guard, but we done already take pictures already, so we
yeah.
have proof that the guard
Yeah,
was
that's,
down.
I
We
mean,
just want
yeah,
to put
putting
it
a
up.
Yeah, putting the guard up and putting it down doesn't make a difference. If you have an injury, like it would not have happened any other way then. With the guard on, it could not have happened, right? Remember, there'd be an investigation into that. There'll be witnesses and whatever have you, right? But look, like the one I'm telling you about where the guy slipped on the pipe. Those pipes are 60 years ago, they're still walking on the pipes, right? But some companies, if they have taken precautions, that doesn't prevent you, it doesn't do anything because there would be an investigation then, right, into what happened, right? Of course, the earlier the better, but there would be an investigation as to what is the common practice throughout the company, right? There was one I had with I don't know if you all have heard this one. I've had one with a guy's name is Christopher. Fire truck went over his foot at the fire station. He didn't do anything. He is not a student anymore. He's actually a lecturer for me today. But at the time of the story, I saw him at Pizza Hut. He was limping. And I'd asked him what had happened. And it was a year and a half after the accident. It was a year and a half. So it's not as if you had to see the physical truck and the physical foot then, right? It's like, this was a year and a half after the truck rolled 10 to 1, whatever they would. I mean, there was nothing to fix there, but he still won his case and he won, a lot of money. Millions, in fact. He left Trinidad a while and went to Canada. I actually saw him this year back in Trinidad. I didn't even know he was back here, right? But Canada is kind of hard to live in now, so probably that's why he's back. But he was away for like a greater part of 10 years, right? All right, folks, you think we could stop here for today? A good class, right? But no past paper questions, right? There's nothing to look back to. There's really nothing,